Good evening. Welcome, everyone. So I'm so happy to see everyone here and those who are attending on our Zoom feed. I, of course, first want to thank our dear friends at Wilmer Hale for hosting us tonight in this lovely space. And I want to thank you all for coming today. I'm Frank Bailey. I'm the president of the Pioneer Public Interest Law Center. This is our third Supreme Court review called Reasonable Minds Can Differ. I hope there's some differences tonight too. And I'll talk a little more about that. But I want to welcome you on behalf of the Pioneer Public Interest Law Center for joining us tonight. And I have a very special thing to do now, and that's to introduce you to Natalie Logan, who is our co-sponsor, here to speak on behalf of our co-sponsor tonight. So, Natalie.
I failed to request the stool to stand on, so I apologize. And I just heard that I'm, shorter in real life than people expect, which I hear a lot about my personality. But thank you, Frank, so much. And thank you to Pioneer for inviting NELF to co-sponsor this event. NELF traditionally puts on a similar event each year to review the Supreme Court docket and the important cases that are coming before the court and really impacting the nation. I also requested that theme music. But I think it's going to be, it is, Red Sox season is almost upon us. It feels like everyone should have a walk-up song. No, but I'm very honored to be here with Frank tonight. I think now more than ever, the existence of organizations like Pioneer and NELF and the work that we're doing is more important now, perhaps, than it's, ever been, to bring consistency and kind of a calm, cool, collected approach to what we're doing when we think about protecting democracy, free enterprise, rule of law, and reviewing issues and being able to have discussions and have differences in opinion as we discuss the issues that are before this nation. So thank you so much for having us. We hope that you enjoy the event, and I hope to meet many of you afterward.
Thank you so much. NELF is something that's near and dear to my heart. I served on its board years ago, and we have, since we've been in existence for almost 3 years, we have collaborated with NELF on a few different cases, and many times we find ourselves filing briefs in the same cases. And once in a while, they're on the other side. I can't quite figure that part out, but that does happen. A few logistics for this evening. If you have questions, please feel free to write them out on the pad, on the paper. We've left a pen or pencil and paper. Write them out, hold them up, and John will be circulating, and we'll pick up your question, and we'll get to them all, provided there is time at the end. Most years, certainly the last two, it's been easy to fill the time that we allot to the program to the cases pending before the U.S. Supreme Court. This is an odd year. There are fewer sort of blockbuster cases than we have had in recent years. We could never get to more than 5, but we didn't think that we would be doing the program a service by simply discussing the 3 or 4 cases that merit discussion this year at the Supreme Court. Certainly not in a year when the real issue, in our country and probably constitutionally, are the battlefield is in executive orders at the moment, and so we have constitutional law experts here, and we would be negligent, if we didn't ask them to comment on executive orders. Probably on a more general basis. We couldn't possibly go through each of them, even though that would probably make for a very interesting program. And so it's going to appear that we're a little jumpier than in other years, because we're going to go from discussing, I'll set up the case, ask for our experts to comment on them, and then we'll move on eventually to the executive orders, and also on and some other issues. And please, again, everything's fair game. So if you have a question that you want to ask, please write it out, indicate. You'll see John roaming around, provide it to him. So I'm delighted to have to introduce you to our speakers, Professor Renée Landers, who is actually teaching at the University of Indiana in Bloomington at this semester. So we're delighted that she was able to come back to join us. She is a professor of law and the faculty director of the Health and Biomedical. Oh, I'm supposed to be flipping these things, aren't I? See that? Yeah. All right. You give me too many things to do, but okay. I asked for it. All right. Here we go. All right, John, I do need some help. I push buttons and nothing
Aim it
happens.
at the
So,
projector.
oh, I have to aim at the projector. This is unnecessary now, right? No? No? That's it. All right, that's us. All right. And there's Professor Landers. And I am really okay. All right. I've never been accused of being too quiet, but I'll try to keep it up louder then. Renée and I spend time each year at the American Bar Association, where we're on the Massachusetts delegation, and I've gotten to know her much better as a result of that work. I'm also delighted to introduce to you Kent Greenfield. Kent is a professor and Dean's Distinguished Scholar at Boston College Law School. I know he must be very good because my son tells me he avoided Kent's class. So I know he's challenging anyway. Kent clerked for Justice Souter, and he is a leader at the American Constitutional Law Society. We're going to hear a little more about that in just a few moments. So we're delighted to have these members of our panel tonight. So we're going to start. This is the lightning round, which is going to come at the beginning rather than at the end. And we'll talk about a few cases. The first case that I want to address is, John, you move, good man. All right. TikTok versus Garland, a case that has been decided, but one that is certainly one of the most important cases of the term. So what's the case all about? You may well know, but TikTok is a U.S. company. However, it is wholly owned by a Chinese company, and ByteDance. And you might know that in China, private companies are all statutorily required to make information available to the Chinese government, and that certainly includes ByteDance. ByteDance has access to all of the information that's available at TikTok. So in 2020, President Trump issued an executive order, and he essentially ordered that he put TikTok on a time frame for it to be disinvested from ByteDance. He identified, and probably quite rightly, national security concerns. And when after he left office, President Biden continued in that effort, and Congress stepped in. Congress passed a statute that required ByteDance to relinquish control and ownership of TikTok by a date certain, essentially 170 days after the statute was passed. TikTok sued, and their essential argument was under the First Amendment, saying that it violated their First Amendment rights and the First Amendment rights of their participants. Who's been on TikTok? Yeah, we are. That makes us old. It's pretty darn clear, but okay. It didn't affect my life, I can tell you right now. However, the TikTok filed a lawsuit. The DC Circuit upheld the statute, finding that it was not, the statute didn't violate the First Amendment, and it applied a heightened scrutiny standard in doing so. National security, it found, was a compelling interest. TikTok on appeal, in its appeal, argued that the statute is facially relates to protected content, and identified the fact that it exempts applications that are primarily product or travel or sales related. So the government sought to apply an order, a intermediate level of scrutiny. So we know what the Supreme Court did, or we'll hear about it now. So this case teed up a very important issue in America, and that is the ability of the government to control social media platforms on a national security basis. So I'll turn to you guys and ask about any comments that you might have about TikTok.
Based on Renee's look at me, I think I should take the lead here. It's a pleasure to be here tonight. Thank you, Frank, for the invitation. It's a pleasure and honor to be on the panel with Renée, such a distinguished scholar.
And by the way, my son isn't here. He's still avoiding you. It appears.
It may not be about quality. It might be about something else, or lack thereof. But I am reminded, like anytime I'm invited to speak to such a distinguished crowd, I'm reminded of the old story about the patient going to the doctor, and the doctor, after some tests, say, "I'm really sorry, but you only have 3 months to live." And the patient, oh my God, what should I do? And the doctor says, "I think you should marry a law professor." Like, well, why would that help? And so, it won't, but it will make the next 3 months feel like forever. So I will try to be more interesting than that, if that's the bar. So the court unanimously held against TikTok and the users of TikTok. And let me say, right, I think one of the interesting things about it, a couple of interesting things. First of all, this court is probably the most First Amendment speech protective court in history. I mean, I think we have the most protective legal framework for speech of any country in the world at any time in history. Yet this court still held against the First Amendment arguments in this case. So I think sort of surprisingly, in the sense that it was unanimous, I think the court probably didn't give enough credence to the First Amendment arguments, and I think they probably gave too much credence to the compelling interest arguments, the national security arguments on the other side. But it may be like, if this crowd may not be the crowd to make judgments about social media and technology, and the court may not be the right crowd either. And so maybe this is one of those situations in which the level of expertise was just not there. But what I think is really fascinating about this case, even what was amazing about it, is that Congress passed this law in a bipartisan way, right? President Biden signed it into law. The court, at every iteration, the courts decided against TikTok and the TikTok users. And in fact, the Friday before Trump was inaugurated, TikTok went dark. And I think the experience of those few hours makes me think that the First Amendment arguments at the court were sort of understated. What's interesting is that immediately after taking office, President Trump said, we're not going to put this into effect. In fact, he gave TikTok permission to ignore both the law and the court pronouncement. There is a provision in the statute that gives the president the ability, I think it's for 90 days, the ability to delay the enforcement of the ban if there's an imminent sale. But I don't think anybody thinks that there's an imminent sale. I think Trump just said he didn't think the outcome was right, and he was just not going to require the Justice Department to enforce it. So I think this was one of the first indications in my mind, and I told my students in class that this was going to be a different kind of a situation that we were seeing, where Congress, the president, the courts all agreed that TikTok should shut down, but President Trump said, actually, you don't have to listen to them. You should listen to me.
So the only thing I would add to that, so first of all, thank you very much, Frank, for this lovely invitation. It is a pleasure to be here. There are several friendly faces in the audience. So I appreciate all of you being here tonight to listen to us, and being on the panel with Kent is truly an honor. What I would add to this, there are two things. One is that after the president made this announcement, the Attorney General issued letters to the social media platforms, apps that host TikTok, Apple, Google, so forth, and saying that their continuing to host the platform was not a violation of the statute, which actually is not correct. And so she can say that she's not going to enforce the statute against them if they, continue to engage in hosting the platform in violation of the statute. But the statute is still there, and presumably Congress means for it still to be there. And then I agree with Kent about this was kind of the leading edge of, the pronouncements that, the law is not necessarily going to be respected. On the national security aspect of the case, I guess that's the one area where the court has said that the free speech concerns are less compelling to them. So if you think of the standing case, United States against Clapper, of a few years ago, where the court said that some of the First Amendment concerns of the plaintiffs in that case were too speculative. And so, said they didn't have standing to challenge our national security agency's surveillance of certain people and the conversations and communications of certain activities. So I think national security is maybe one exception that they have to that First Amendment area. And then another exception, which kind of, it gets, bollocksed up in the, spending clause and abortion politics, are in, actually validating laws that require certain statements to be made to patients in the abortion context, and then invalidating laws. California had a law that required facilities that were not healthcare facilities who were giving advice to pregnant women to post a notice saying that they were not healthcare facilities, and here was a website you could go to if you wanted different healthcare. And the court invalidated that statute. So I think there are some areas at the margins where the Supreme Court is a little less concerned about the First Amendment. The last thing I will say on the national security issue, and this intersects with a lot of cases that are percolating in the federal courts and that the Supreme Court has recently decided, is the general data protection regulation that the EU has. The United States has had a very fraught history of efforts to try to ensure that we have a mechanism for allowing the exchange of personal information between Europe and the United States with European citizens. And I won't go into all the details on that because that's not the topic, but to cut to the chase, that the concerns that the Europeans have is, first of all, the US does not have a general data protection statute that conforms to the standards of the GDPR. But second is that we've never been quite able to convince the European Court that our national security agencies don't have unwarranted access to the data that comes into the United States. So on the one hand, we have this concern about China. I'm concerned about China too, but the court has kind of, with our government has kind of, tried to skirt around this issue of what our national security agencies are doing. President Biden, issued an executive order, I want to say 2022, yes, 2022, establish a new relationship called the framework with the EU that presumably will allow these transported data flows to occur. But it has not been rescinded by President Trump, and so one of the few. But I predict that we're going to have a similar kind of failure of that agreement as well, because it's not clear to me that the protections from surveillance by our national security agencies are going to pass muster with the Europeans.
So we'll move on to the next case, but my one observation about this is there is reason to be worried about China, and data. There really is. Soon after I took the bench, and I, of course, had to go through an FBI background check. It's a report that FBI does. I got appointed, so I assume I passed, but I've never seen that report. I can't get that report. And the Chinese have that report. They hacked the OPM, the Office of Personnel Management, and they have mine. They have Justice Kavanaugh's because he was on the DC circuit at the time. And the scary thing that these guys do is they wait, they wait. They're waiting to see what happens. But believe me, they know what's in those reports. Now, they're very bored with my report. I guarantee it. But they might not be so bored with other reports. It's a scary crowd. It's something that we need to be worried about. It's real. So, okay, let's move on. The next case is United States versus Scrumetti. This case is on appeal from the Sixth Circuit. This case involved a Tennessee law that prohibits gender dysphoria treatments. So it's SB 1, and it prohibits healthcare providers from prescribing puberty blockers to children under the age of 18. I believe it's merged now with a case out of Kentucky, which prohibits, bans surgical treatments to children under 18, which would alter the child's appearance in an effort to reaffirm gender choice change. There are exceptions through both of these laws, of course, that have to do with various medical ailments that have historically been present, but these are choice-related statutes. The Sixth Circuit ruled that the statutes were constitutional, and the issue was, do those statutes violate the substantive due process, or equal protection clause? As far as substantive due process is concerned, the Sixth Circuit ruled that considered the right to the court determined, and maybe I should let you guys describe it from there. The Sixth Circuit ruled against the plaintiffs or upheld the statutes in both cases. And I know, Renee, this is right up your alley. And so you'll do a better job of describing what happened than I will.
Right. Well, I'm not sure about that, but I think that, yes, they upheld the statutes. So the issue on substantive due process, they're sort of, is the issue of the parent's ability to control the medical treatment that their children receive. And so, historically, under substance due process doctrine, the parents have been able to make decisions on behalf of minor children. Things like vaccines, other kinds of medical treatments. And that the parents were kind of relying on, those cases in that framework to suggest that these statutes interfere with that ability of the parents. But balanced against that is the state's asserted interest in protecting the children from harmful activity, harmful actions, and that some of which, in the case of surgeries, can't be reversed, although it's not clear to me that a lot of surgeries were happening for minor children, but putting that aside. So the court said that the state's interest outweighed the interest of the parents, and that, when the children get to be 18, then they can make their own decisions in theory, although some states are trying to ban these treatments for adults as well. Then on the equal protection clause side, so first of all, the parents are making some argument that, and the children also, that it's putting these children into a different category, that because of the exceptions that Frank alluded to, that that the treatments can go forward in cases of certain other medical diagnoses, that it was a violation of the Equal Protection Clause to prohibit the use of these treatments for other purposes. The court has rejected that argument as well. And also, the equal protection argument, kind of applies to parents as well, to the extent that they are differently situated or treated differently under the law than the parents of, children seeking other kinds of medical treatment with respect to these particular treatments. So I think the oral argument in the case went very badly for the plaintiffs, the people challenging the law. And I think that there's going to be quite a significant majority upholding those statutes. I don't know what you think.
I think that's right. I can't imagine this court either ruling that transgender status is a protected class subject to heightened scrutiny, or that this is the kind of restriction on medical care that would violate due process. There may be an interesting outcome only because there was an interesting procedural quirk in the case. The petitions for cert were filed not only by the parents, but by the United States government. The court did not grant cert in the petition by the parents, but did grant cert in the petition by the United States government. And as you might imagine, there's been a change in the point of view of the United States government since the court heard the case. So the acting Solicitor General has filed a petition before the court saying that they now want to distance themselves from the argument that the United States was making prior to that. So there is a possibility that the court dismisses as improperly granted the petition and essentially makes the case go away. And in my view, that's the best possible outcome at this point.
Except that more is coming, right? I mean, the First Circuit just had the decision last week in the Foote versus Ludlow school district. We may get to that later, but these cases are coming. I mean, there's
No
just
doubt.
there's just no way to avoid them. The third case that I want to highlight and ask for comments on is Free Speech Coalition versus Paxton. It's a Texas statute, HB 1081, if anybody's taking notes. And that case, it did two things. For quote unquote pornography sites, it requires that the sponsor of the site, the owner of the site, determine whether the age of a person who's accessing the site to ensure that they're not a minor. And the second thing it does is it requires that any of those sites include a health warning about the problems that can occur, particularly to young people, in the event that they are accessing that kind of content. The Plaintiff Free Speech Coalition is an adult industry trade association, and sought to have the statute enjoined on First Amendment grounds. The Fifth Circuit, that the district judge did indeed issue an injunction enjoining the statute. The Fifth Circuit reversed that decision, that injunction in part. It upheld, I hope I have this right, it seemed backwards to me, but it upheld the injunction to the extent that it dealt with the health warnings, but vacated the injunction under the Ginsburg versus New York case. We might all remember that from law school. It's an interesting pornography case, but and therefore the court said that it did not violate the First Amendment based on that case. Again, interesting issues, First Amendment issues, and I wonder what our panelists have to say about it.
Right. Well, I have one thing to say about your comment about, which parts of the order the court, the Fifth Circuit upheld. I understand why the Fifth Circuit would uphold the injunction against the statute that required the health warning, because there's been this evolution in First Amendment law. You probably know more about it than I do, but evolution in First Amendment law about compelled speech, and it's sort of related to
That's exactly right. Yes.
Posted warning that I was talking about in the California case with these clinics that don't provide actual medical care but advice to pregnant women. So the courts have been, first of all, it used to be that there were kind of regulatory exceptions, that there were, that regulators could demand truthful health warnings on the part of business enterprises and other regulated entities. And the ability to do that has slowly and steadily been eroding, saying that the government can actually not put speech in the mouths of these corporate actors. And so, where does that heading? I mean, many of you probably are familiar with the securities laws, right? It's all based on disclosures, required disclosures. So it'll be interesting to see if it evolves to the point that comes into question as well.
Like consumer protection, cigarette package warnings. I think this case is interesting. In fact, in my Supreme Court seminar back in the fall, we argued this case because there's a framework in free speech law that basically makes a distinction between sexually explicit speech that is available to grown-ups and sexually explicit speech that's available to minors. And the court says the standard can be different. You can be more protective of speech that's available to minors, and you can check. Basically, so if you want to go buy a dirty magazine, it's not a violation of the First Amendment for you to have to show your ID to prove that you can buy the magazine. What Texas was doing was that they, instead of in the magazine context where you go up to the counter, they were requiring you to have your license or identification scanned into the, into the internet, basically. And so people said, the argument is that that's a burden. Like, I don't know what, where my ID is going to go. And it's, we're all, like, I'm embarrassed. I don't want to, people be able to track what I'm looking at. But analytically, it's sort of interesting, right? In the sense that if you're a grown-up, your restrictions are much less than if you're a minor. And the question is at that decision tree, split in the road, can they create a signpost or a toll booth that says you gotta prove which branch of this decision tree you go down, and whether showing that ID at that toll booth is a burden on speech. So I think analytically it's pretty interesting, and it's a good case for law students to argue. I don't think it's a blockbuster First Amendment case. but it is, you know, it's about as big of a case we have as this year until the cases are about to talk about.
Right. Okay. So, you know, I actually went back and read Ginsburg versus New York today, and the greatest impact that it had on me was I realized, you know, how far the world has come since 1968, because the facts of that case, as described by Justice Brennan, are that a 16-year-old went into Mr. Ginsburg's deli, where they had some magazines, and bought a quote unquote girly magazine. Now, which part of that is the most offensive? I don't know, really. You know, but anyway, I can't imagine any justice of the Supreme Court using that language today. So we're going to move on now to executive orders. I have a few slides I want to talk about just to give you a perspective. And John, you're moving them, right? Very good. All right. So let's just take a look in recent years. President Obama signed 227 executive orders in between 2009 and 2017. I should have gone back earlier, but so 227 executive orders. President Trump signed 220 between 2017 and 2020 with an outsized year in 2020 of 69, maybe related to the pandemic, maybe related to the end of his term. President Biden then signed 162 executive orders. So the guys are using this, right? Including 77 executive orders in 2021, no doubt reversing much of what President Trump did toward the end of his term. And to identify just a couple of these executive orders that are most in the press. The first is the rather famous one, Executive Order 14160, which is ending birthright citizenship. That kind of overstates it a little bit. It doesn't really do that, but if a mother is unlawfully in the U.S. and the father is not a legal citizen of the U.S., that person under the executive order would not be an American citizen, notwithstanding the 14th Amendment's language. And then there's another aspect of it that says that if a mother was in the U.S. lawfully but temporarily, also their child would not be an American citizen under the 14th Amendment. The second one to highlight is the Office of Management and Budget spending freeze, and I won't go into details on these, but I said that it was rescinded by the president, but also frozen by a federal district judge. The next one, so the world's changing, right? So the issue of Executive Order 114101, requiring the transfer of transgender female prisoners to male-only prisons, which was also frozen by a federal district judge. And the executive order, maybe this is the big kahuna of the year, but allowing the Department of Government Efficiency, DOGE, access to the Treasury payment system, again, limited and frozen, and then I believe unfrozen, but still limited. So they can have read-only access is what I believe they've been given at this point by the court. And none of these have quite, I don't believe, have made their way to the Supreme Court yet, but they're certainly on their way. And finally, the buyout of federal workers, 2 million federal workers. It does say something that I think 75,000 took it, right? So that what they got was, if they resigned within 1 week of the January 20th order, they would be paid through the end of the fiscal year. So they'd be paid all the way through September 30th. And 75,000 workers did take it. And so this is where I want to lateral to you guys and executive orders. You know, it's what we're all reading about every day. And Ken, do you want to start us on this?
Sure. Yeah. And you all No, right, you've been reading every day. This was just an abbreviated list of the other executive orders. There have been executive orders aimed at universities, government contractors, to end any DEI program. There have been letters aimed at schools, universities that seek to end government funding for any school or university that protects trans athletes. There have been, attempted firings of independent agency heads and watchdogs like Hampton Dellinger. There's been the defunding of the USAID, which is currently under an injunction. So I think the thing to say, we can sort of talk about individual ones, but I think the thing to say is I think we are in a crisis, because we have a president and an administration that for the first time in my life seems to not care if they're acting illegal or unconstitutionally. Now, we've had presidents who have issued executive orders that I thought were illegal or even unconstitutional. But I've never seen a situation in which the administration has been uncaring and openly derisive of law. President Trump tweeted, I still use the word tweet, it is, tweeted last week, "He who saves his country does not break any law." That's outrageous. He tweeted a picture of him in a crown. The White House issued on their official webpage, social media page, a picture of President Trump in a crown. He is not king. I was 2 weeks ago, I was talking to some of my colleagues and like, why hasn't there been a law professor's letter, right? And of course, filled with hubris, what's going to stop this is a letter from law professors. And so I wrote a letter, wrote a statement, and I asked some of my friends to be initial signatories, and I sent it around. And over the course of the last week, we've gotten 1,000 signatures to this statement. It's been published. I think Frank has got a link, or I can give you a link.
I put up,
and so you can't get 1,000 law professors to agree what day it is. But we have at least 1,000 law professors from around the country saying we are in a constitutional crisis. And I think we are. Renée was one of the signatories. I'm so proud that we have her name associated with it. And I think, I'm teaching common law right now, and I can't imagine a worse time to be teaching or learning constitutional law, because I'm not sure where we're going to be in 6 months in all likelihood. I think I can imagine an outcome in which our country is made better from this, that rule of law is strengthened, that courts are strengthened, that social institutions are like this institute, like law professors, like colleges, universities, like the ABA, rise up to be oppositional forces in this moment when the rule of law is under attack. But I can also imagine that this makes our country weaker, and significantly so. And I think the next 6 months or so, maybe even the next 6 days, who knows, things happen fast. Next 6 months or so may be pivotal.
So I think the important thing to say here about what's happening is that it's not really, a comment on the substance. I mean, I will own that I disagree with a lot of the substance that's reflected in these executive orders, but there's a way to accomplish that substance that conforms with law. And this approach is not the right approach. And so, and I think a lot of the executive orders, the point is not really necessarily to affect an immediate change in the policy, because I think they recognize that these policies are going to be challenged in the courts. but it's performative. A lot of the titles of the executive orders are very tendentious. And I think that, and so it's really a signaling function about the politics of the policies and not so much about what the actual implementation is going to be. So I think that that's also kind of concerning. And so, and then finally, I would say that, you know, because certain aspects of these executive orders are unlawful, I hope that people, like Kent, I hope people don't just say, well, you know, it's just, you know, sticking our head up in this moment is too complicated and too risky. And so we'll just go along to get along, keep our grant money flowing and all that sort of thing. Keep the ABA as the accreditor of law schools, keep that, you know, keep that gig going. And I hope people don't do that. I hope that they really will stand up for, you know, what the principles are here.
Well, what is the role of an executive order? I mean, the pandemic hits and the president, whoever it is, issues an order saying you all must work from home now, right? So that doesn't seem unreasonable to me, right?
Well, I'm not sure the president actually, I think the president encouraged that, but it's really the states did that, said to the states, perhaps you ought to issue orders because the governors, the
I'm not saying
states,
it happened that way.
Yeah.
I'm saying if it were to happen that way, that wouldn't be unreasonable. That would be an appropriate use of an executive order.
Right. Executive orders are not, right. Executive orders are a time-tested way for the president to execute the law, right? And there are some statutes that explicitly empower the president to issue executive orders to designate national disasters, for example. But I think what's different about the situation in which we find ourselves now is that the executive orders are like explicitly performatively lawless. The ending birthright citizenship, he knows that's unconstitutional.
There's an argument, but the president cannot.
Yes, but all right. So if we're going to engage, so that would require the overturning of a president that's over 100 years old. The president cannot overturn a president that's 100 years old.
No, it wasn't. Well,
but the president can't overturn that. The president is not cannot overturn an amendment, cannot overturn a Supreme Court case. That is not what he's done. He's acting unconstitutionally and illegally and knowingly so. He is knowingly. I'm sorry.
That's why we have courts.
No, he actually signed his name to that executive order. That is an illegal act. He is under a constitutional obligation to faithfully execute the laws of the United States and protect the Constitution. He cannot just by whim decide which laws and which amendments to abide by and which ones not to.
It isn't the proper way, I think, to test the scope and meaning of the 14th Amendment. You know,
well, the real test will come is if based on that executive order, the immigration enforcement agencies, you know, take some actions or some states deny, you know, U.S. birth certificates or something like that to people who are born. I think February 19th was the date. Yeah,
there will certainly.
There will be certainly.
So we're going to do questions in a moment, but let's flip the slide to the next thing, and because I don't want to miss it. All right, and Renee, I think this is headed your way for the most part. So the appointment power. The other big issue that I wanted to hit tonight, you know, is the appointment power of the president, which is of course lodged in Article 2, Section 2, Clause 2, and requires that this is my word, not the Constitution's, any senior officer, but I think it just says officer. Yeah, of the United States should be appointed by the president, confirmed by the Senate. Inferior officers may be appointed by the president with a report to Congress. Am I right? I won't test your memory, yeah. But there are circumstances where inferior officers, of course, can be appointed by the president without confirmation by the Senate, right? Next slide. of course, I'm talking about Doge and I'm talking about Elon Musk. And is Elon Musk a properly appointed officer of the United States? Seems to be acting like one. So the question is, is he acting properly with authority? And I do have this question for both of you. What if he's not? What does all that mean?
So I would argue that he's not, because you've had, several confirmation hearings of other officials with related functions in the government now. When asked under oath at their Senate confirmation hearings, they could not say what his job was, say who appointed him, and these are Trump administration officials. So I think that the answer is this, this effort to say, well, he's doing things that people like, or some people like anyway, and so therefore, the president is entitled to have whoever he wants. But I see several problems with this, and maybe I hope I'm not anticipating your later points in this conversation, Frank. But first of all, Elon Musk contributed $250 million to President Trump's campaign. Elon Musk is actually a significant federal contractor with numerous federal agencies, well, at least 3 or 4. And so, and he has not been subjected to any kind of rigorous examination or limitation of his role or duties, as far as we know, to police those conflicts like other Senate confirmed appointees would have been. And so I think, Elon Musk has a lot of power because he gave a lot of money, and he is in a position to control the federal agencies with whom he would like to have continuing business. And I think this is a scandal for our country that this is happening.
I think one measure of the scandal was in the district court in DC last week when the firings were challenged. The district judge asked the U.S. Lawyer who the administrator of Doge was, and the lawyer, there was no administrator, and the lawyer couldn't say. And it's not Elon Musk, so there's no power, there's no authority there.
My understanding is that an appointed official can act with authority provided they are reporting to, I think this is Supreme Court law, provided they are reporting to an officer who has been properly confirmed by the Senate, right? So couldn't the argument be made that Musk is reporting to the president and therefore actually more than meets the obligation under the appointments clause?
Well, I would say, technically there's an argument there, but if we think that, one of the roles of law in this whole set of enterprises is to make sure that people are acting in the interests of the United States and not their own interests, that this is a whole big end run around the procedures that have been put in place to try to enforce that.
Isn't it easily fixed, though? I mean, the Senate is a Republican Senate. I mean, if they present.
Yeah, no, it is. Yeah, yes, it is totally. But they're not doing that.
I think the bigger problem is actually not his status. The bigger problem is what he and the president are doing with regard to these administrative agencies, right? What power do they have to impound funds? I think that's
definitely an issue.
That's a question. Yeah.
Right. Okay. We have lots of questions coming up. We're not going to get to them all, but I'm going to, if John can bring them up, I'll come on up. It's okay.
Everybody hear me? My name is Barbara Anthony.
And Barbara, the rule of law does apply here. And the rule of law says, write it out. Yeah.
Okay.
Thanks, Barbara.
She's kind of a safe questioner for you all, though.
Okay. So part 2 of this will be tomorrow morning starting at 9 a.m. and then we'll resume on Wednesday morning at 9 a.m. And I think by Friday we'll have All right, I'm going to start with the top one. Wouldn't any executive order banning DEI programs in the private sector violate the First Amendment under the unconstitutional conditions doctrine?
Yes.
Yeah.
Next question.
As so ruled by last week in the case in Maryland. Yes.
The Supreme Court takes very few IP cases, as well as other less exciting areas of the law, like bankruptcy, that have many circuit splits. How can that be fixed? So this is a Supreme Court question. I love this question, though. You know what? I view this as kind of, they're taking 80 cases a year. I mean, come on, guys. You know, when you clerked, how many cases were they taking?
Probably 95.
That's a
Not that
significant
much.
difference, right? That's
yeah.
You're not that old, so you know.
But
No,
but
yeah.
then in, you know, sort of, you know, another generation back, they were
Right.
they were deciding 150,
125,
yeah,
150,
125, 150
Right.
cases a year. So, and then if you think about the amount of resources that are devoted to the Supreme Court compared to, you know, what the average district judge gets with a much more significant docket, I think that, you know, really, what are we paying them for? And so, so what could be done to fix it? So
Right.
one thing is that Congress could pass a statute that would eliminate the exclusive control they have over their docket. There's a law professor who used to be at Texas and he's now at Georgetown, Steve Vladeck, who has, I don't know, what is his thing? Is it a blog? Is it a, I don't know, commentary? I don't know what his thing is, but he publishes, you know,
It's
regular.
a Substack. I think.
Yeah, Substack. It's on Substack. And, you know, and his idea is that, you know, the trouble with the Supreme Court started when they did not used to have this control of their docket. And then at some point, I forget when it was, they were able to persuade Congress to give them exclusive control with very minor exceptions of their docket. And that's when the trouble started. And when they started focusing on these, you know, high profile cases and not doing so many of them.
Right. One of the things when I take my students to the Supreme Court, one of the things that I think comes out of that experience is that on the non-ideological cases, they're a really careful group of very smart lawyers, and they do a really careful job at these cases, and it's impressive. It's impressive. And I think the ideological cases, I think it's more complicated than that. But these kinds of cases, IP or bankruptcy or what have you, it's a very competent court.
Right. So, all right. Can Congress pass a law ending birthright citizenship?
No.
I don't think so either. It's a constitutional amendment that would be required. You'd have to amend the 14th Amendment, I think, to do it. So,
and we shouldn't. We fought a civil war over this. Like, that's a pretty important part of the Constitution.
And if you think that history is irrelevant, I read that Today in History column in the Boston Globe, you know, every day. And you learn some important things by reading that column. Which I've learned recently is that the state of Mississippi ratified the 14th Amendment in 2013. And they ratified the 13th Amendment in 1995. So, you know, there's a lot of traction against these things like birthright citizenship that we think are probably settled law and that we fought a war over, but there's still a lot of pulling back.
I think this is a great question. If the concern is data privacy in the case that we discussed, wouldn't national security interests be better served by requiring all social media companies to stop mining our data rather than banning foreign ownership of social media companies?
Yes.
So that's a policy
Yes.
question,
Right.
I suppose.
Yes, and Congress should do it.
Congress should do it.
And they
right.
have not done it.
Right.
And against, even with all of these problems, some of which I already described, they have not done it.
The difficulty with this is, you know, the court decided a case out of Vermont a few years ago in which it held that data are speech. Data and the exchange of data cannot be restricted without restricting speech. So if data is speech, I think it's correct to say data are speech, but it doesn't sound right.
Right.
If that is speech, then that even that law would be unconstitutional.
Well, is this the health?
Yeah.
Yeah, yeah. So, but see, I think that got bollocksed up in the ERISA preemption issue because it was a Vermont statute. It wasn't a federal statute. So I think that perhaps that
I hope.
a federal statute could accomplish what that Vermont, and because in fact, I think the court said in that case that, well, the Department of Labor could require this reporting. And it has, by regulation, it has chosen not to, to require insurers to report this data. And the problem is just Vermont can't do it.
Well, the Supreme Court has shown great disinclination for doing much in the way of regulating social media, right? I mean, the Google case from 2 years ago. So so this is a great question too, regarding the TikTok case again, but was the Fifth Amendment takings clause issue before the Supreme Court or the DC Circuit? And I don't know if it was or wasn't. It's not in what I read, but what do you think about a takings argument by TikTok in the event that that statute were to be deemed to be constitutional? Is that not a taking?
Not a regulatory taking, because it just required the sale of it to a different entity. But yeah, I haven't thought about the taking part of it. That's interesting. Don't know.
I think Pioneer likes that argument. So if they call us, maybe we'll take it. It's an interesting problem.
Yeah, that is, but you think about it, sort of one day a certain set of activities are legal, and then legislatures enact a statute or the public votes in a referendum, and the statute, that set of activities are no longer legal. We don't compensate the companies that used to be engaged in this business. I'm thinking of the poster child example I always give my students is the elimination of greyhound racing in Massachusetts. Referendum question comes, the public votes, and 2 years later, all of those companies are out of business, no compensation for the value of those companies.
Right. Mm-hmm. For you, Kent, you made a reference earlier to the fact this is the most First Amendment friendly Supreme Court in history. And how about the Murphy versus Missouri case? How was it? I don't have the question exactly right here. I'll just read it. Why was Murphy v. Missouri decided how it was? I don't know the case, so I can't.
And I feel like one of my students was not prepared for the question in class. Where's this question from?
This is that case that was about, yeah.
Years ago.
He got you back, right?
So, which case is this?
Where, just to be quick, it was the case where the Biden administration was telling social media companies through back channels, well, you should take down.
Oh, okay. Yeah.
Yeah.
Right. Sorry.
And the Fifth Circuit said that's illegal, and the Supreme Court just kind of.
Wait, before we go any further, what'd you get in the club? What'd you get in the club? Never mind, you don't have to tell us. I'm sorry.
Yeah. I think the question in that case is to what extent, and I think this was in the era where there was a bunch of COVID disinformation, and the question was whether how influential the Biden administration could be in
whether it was coercive,
right?
Yeah, whether it was coercive, right?
Vis-a-vis the social media companies, that they should stop posting this information. And I think it all turns on whether it's a coercion or not. And I think the question of coercion is really tricky. How much influence on your decision making is coercive? How much of it is just encouragement? And I think the court does not want to decide that.
And also, this court has, people on it who were officials in executive branch. And I think Kavanaugh actually said at the oral argument, well, I did that. That was part of my job, is to call people and tell them that we don't like stuff that they were putting out. So I think that it kind of ran up against that kind of practical problem too.
So I think a lot of what we hear in the room and outside the room does come down to this. Can you contrast President Trump's approach to executive orders with President Biden's approach? Are we being a bit result oriented, right? So, if we say, well, I don't agree with the substance of the Trump orders, that's sort of one thing, right? But I do agree with what Biden did, but he still was using executive orders. Can we contrast those, or is it really just result oriented that we're?
I don't think it's a fair question, right? And I think it's reasonable to ask it. I don't think it's result oriented. Look, there's I agree with Renee. There's some of these executive orders that certainly the 1,000 law professors that signed this statement, some of them agreed with one of them as a policy matter. Some of us disagreed with them. But I think the level of sort of refusal to take seriously the constraints of law and the Constitution is different under this, and we have evidence of that, right? We have courts saying to the executive branch lawyers appearing before them, show me how you've abided by this injunction, and there's already indications that they're not. So, whether we will have a full-blown I refuse to abide by this order, I think is yet to be seen. Right. But I think we are in a different world.
So an example, an example that I care about is the statement that, from here on out, NIH will pay only 15% of the grant, for indirect costs. And, indirect costs is, like health law nerd, but stuff. But on that, that policy statement, I don't think that was an executive order, but first of all, there are existing grants that gets to the impoundment issue where, given with the assumption that the indirect costs negotiated rates with the agencies would be enforced. Second, there are regulations that establish the process for establishing the indirect cost rates, and a process, and you'd have to go through that process to change the rates. So this is all trying to operate outside of the law. And then finally, in the face of the court injunction, the response of the administration was to close the operations of the Federal Register so that then there could be no meeting notices of grant making that's already authorized, but they're just now deciding on who's receiving the grants. There can be no meetings of those grant advisory committees because they can't give the public meeting notices because the Federal Register has been shut down. And so that's really kind of willful violation of the court order, I think. I applaud the cleverness of it, but I think that it's really not really a good faith attempt to adhere to the court order.
Well, this is our third year, and I think this surpasses the questions we received in the last 2 years combined. In fact, I'm sure of it, and I can't do any more. So, yes, thank you so much to our panel. Thank you all for coming tonight.